that's a benefit then, right?
Yeah. Okay, we're going to get started. Good afternoon, everyone, and thank you so much for attending the Duke Journal of Gender Law and Policy Symposium. My name is Ann Dana, and along with Amy Rubin, I'm delighted to present today's speakers. Today's topic is current developments regarding the LGBT community and the law. We'd like to thank OUTlaw for the pizza, and we'd also like to give a special thanks to Gina and Adam for making the symposium so great this year. We also wanted to let everyone know about the other journal symposium taking place this week. The Duke Forum for Law and Social Change will be holding a day-long symposium entitled The New Face of Discrimination, Muslim in America, and we encourage all of you guys to check that out. Turning to our speakers, it's my pleasure to introduce our first speaker today, Courtney Powers. Ms. Powers received her JD from UCLA Law School, where she was the co-editor-in-chief of the Women's Law Journal, and she received the Women for Change 2000 Student Leadership Award. She currently serves as the vice president of the Women Lawyers Association of Los Angeles and teaches a course on women and the law at Mount St. Mary's College. She's here today presenting her article, Finding LGBTs a Suspect Class, Assessing the Political Power of LGBTs as a Basis for the Court's Application of Heightened Scrutiny. Amy?
And it is my pleasure to introduce Mr. Mark Strasser. He is a Trustees Professor of Law at Capital University Law School in Columbus, Ohio. He attended Harvard College and earned a master's and PhD from the University of Chicago and received his JD from Stanford Law School. Today he will be discussing his essay entitled Life After DOMA. In this paper, he explores what DOMA, the Federal Defense of Marriage Act, does, what would happen if it did not continue to exist, and the potential ramifications for some same-sex couples. Without further ado, Ms. Courtney Powers.
I think I'm going to start. Thanks for having me. I guess I wanted to start off by thanking everyone at the Journal for putting this on. I was in your shoes not too long ago, so I understand sort of the work that goes into it, which is really important in terms of both your publishing and your symposium. So I'm here today to talk about my paper, and particularly the timely nature of the argument given the challenge to Proposition 8 pending in federal court in California, which I'm sure a lot of you have been following. So in my paper, I argue that the U.S. Supreme Court should apply heightened scrutiny to laws treating LGBTs differently on the basis that LGBTs are a politically powerless minority group. Application of this type of scrutiny would make it extremely hard for a law treating LGBTs differently to survive a constitutional attack. And this type of scrutiny is exactly what the California Supreme Court applied to a law defining marriage as between men and women and invalidated it as a result, which is why same-sex marriage was actually legal in California for about a 6-month period of time. The U.S. Supreme Court, as of yet, has not applied heightened scrutiny to a law treating LGBTs differently, but it has never said that it wouldn't, and it has never reviewed a same-sex marriage case before. And that is something that could change fairly soon. So in California, our electorate approved an actual amendment to our Constitution called Proposition 8, which defines marriage as between a man and a woman. It has been challenged in federal court up in San Francisco. The trial in that case began several weeks ago. Judge Walker, who is a Bush 1 appointee, has been presiding. Both sides have presented their evidence. So that part of the case is over, and I believe closing arguments are scheduled for about a month from now. So everyone expects that the outcome of that case is going to be appealed, and that it could very likely be a case selected by the U.S. Supreme Court for review. So the argument that I'm putting forth today to you and in the paper would really strengthen the basis by which the court could apply heightened review to a law like Proposition 8 and invalidated it. So I want to start with a quick review of constitutional law. I'm not sure if everyone has had the course, or maybe you've chosen to forget about it as quickly as possible. So our Constitution under the 14th Amendment provides for equal protection under the laws, which means that similarly situated people must be treated similarly. And we generally defer to our legislative institutions to ensure that the laws they pass afford equal protection. So as an example, let's say North Carolina passed a law saying you have to be 16 to drive. I don't know, is that a law here? Probably. So we have a law, let's say it treats two groups of people differently, those 16 and older compared to those under 16, and we ask, is that a law that affords equal protection even though it's treating people differently? And we say, yeah, we do. We're comfortable with that law because there's a good reason for the distinction, right? Arguably, those that are 16 and older are going to be more safe, more responsible drivers compared to those under 16. They're not similarly situated with respect to their driving abilities. But let's say the state passed a law saying if you're a Caucasian person, you can drive. If you're a person of color, you can't. Or if you're a man, you can drive, but if you're a woman, you cannot. Would those laws afford equal protection? Well, obviously not, because there's not a good reason for that distinction, right? Men and women, there is no real difference in terms of their driving ability. They are similarly situated in that regard. So in that type of scenario, we begin to suspect or assume that the real motivation in the legislature in passing that law was not a real difference between men and women, but perhaps discrimination, perhaps a stereotype of the role of women in our society, particularly given that women have faced a history of discrimination in our country. So the courts have found certain groups, let's say people of color, let's say women, as suspect classes, and have decided to apply heightened scrutiny to laws that treat those classes differently. So the courts would apply heightened review to a law allowing men but not women to drive, and under that review would ask the government to come up with an exceedingly persuasive justification as to why it was making that distinction. Maybe that's a term you remember from your con law class. And guess what? It's extremely difficult for the government to meet that burden because there's hardly, if ever, a good reason to be treating men and women differently. And that's because there's hardly, if ever, any difference in their abilities. So I mentioned that the Supreme Court has not yet considered LGBTs to be a suspect class. So if it was continuing on that precedent, it would look at a law treating LGBTs differently and apply a much lower level of review, asking the government only to come up with some good legitimate reason as to why it was treating LGBT people differently. So this question of whether LGBTs are a suspect class or not is highly consequential, right? If the court considers them to be suspect, it's going to apply heightened review and is very likely to strike down a statute. And if not, it makes the burden on the government much easier to justify the statute. So if you've been following the Prop 8 litigation, this is one of the main issues being litigated in this case. What standard of review, should it be heightened or not, should be applied to a law treating LGBTs differently. So the question becomes, so how does a court figure out whether a group is deserving or merits heightened review? How does it go about determining that? So the court has typically focused on a set of criteria. One is whether the group at hand has faced a history of discrimination in our country. Another is whether the group bears a characteristic that influences that group's ability to contribute to society. And also whether the group bears a characteristic that is immutable. Is it something that you can change about yourself or not? And sometimes courts have looked at other factors, and sometimes one of that other factors they have looked at is whether the group has political power or not. And sort of the logic there is, you know, if my group lacks political power to protect me and my group in the legislative process from passing a law that may deny me equal protection, then we want and we need the court to step in and apply heightened review and look at that law very closely to make sure it does not deny equal protection. And in fact, in the Prop 8 litigation, I mentioned that some courts have looked at this and some haven't. Judge Walker in the Prop 8 case explicitly called out this idea of political power as an element he wanted both parties to present evidence on, as an element he wanted to resolve in the litigation, which gives us a clue that this is something he's going to take into account when he's making his decision. And in fact, both sides in the case presented testimony. They both called political scientists to the witness stand to testify on this issue of political power. So the next relevant question is, how do LGBTs fare under this sort of criteria that I laid out? Certainly LGBTs have a history of discrimination in our country. Certainly being gay doesn't influence like your ability to contribute to society. And those are 2 points where both sides in the Prop 8 litigation actually agreed on, so there isn't really any factual issues there. And the real debate comes in on the other factors. Is your sexual orientation something you can change about yourself? And this was a factual issue that came up in the Prop 8 case. And I think more and more courts, like the California Supreme Court, have started to frame that question a little bit differently. And they're asking not whether your sexual orientation is something you can change about yourself, but is it something you can change about yourself without incurring damage to who you are as a person? Or should it be something you should be asked to change about yourself? Which makes it much easier for the court to conclude that that's not possible, that it isn't something you can change. So just kind of based on those first 3 factors alone, I kind of look at that and say, gee, you know, there's already a very strong basis by which the court could find LGBTs to be a suspect class, just based on those 3 factors alone. You know, I'm sort of skeptical as if they will or not, and I think a lot of people are skeptical just based on the conservative makeup of the court. I think based on a real hesitancy by the court to start adding new suspect classes and applying heightened scrutiny to more and more laws, which I think there's a concern about separation of powers there in terms of the legislative branch and the judiciary. And probably I'm just, you know, a pessimistic person about these things, but I think all of these concerns really drove a lot of the dissension within the LGBT community about whether this litigation should have been filed at all, and whether it was too early to be challenging Proposition 8, and perhaps it will go to the Supreme Court, and perhaps there will be a negative outcome and set some bad precedent. So, you know, that's something that's all sort of up for debate, and the train is now sort of rolling ahead with this litigation. But, you know, I do think if the court could find LGBTs to be a politically powerless minority group, that's certainly going to help the case, and maybe it could serve as sort of a tipping point in the court's analysis when they're trying to figure out whether LGBTs should be considered a suspect class or not. So then the next question is, so how does the court go about finding whether a group has political power or not? There's certainly a lot of different ways you could go about looking at that question. What I argue in my paper is that I think the real concern should be whether LGBTs are respected in the legislative process. whether their interests are really taken into account by the legislators, or are they more marginalized? Can a legislator identify with or understand the needs of a particular group? And just as an example, that was used actually by Justice Marshall in one of his opinions is, we don't consider children to be politically powerless, even though there are no kids serving in our legislative institutions. And that's because I think all legislators used to be kids, and most of them have kids. So we sort of trust that they can speak with some authority as to, what laws they should pass or not pass concerning the interests of children. I don't think the same can be said for LGBTs. I don't think most non-LGBT legislators have a great understanding of what it's like to be gay in this country. I suspect that a lot of them, particularly in the more rural areas of our country, lack contact with the community. And I think just statistically, most are not going to have an openly gay person as part of their immediate family. So I think there's a problem with sort of relying on non-LGBT legislators. I think the real measure of this type of respect that I'm talking about is how many openly gay persons are serving in our legislative institutions. These are people that can speak directly as to the needs of the community. They're more likely to champion legislation which would be helpful to the community. There's research that shows as the number of LGBT legislators in state houses rises, so does the number of bills introduced and passed by those houses which are helpful to the community. I think it's more likely that an openly LGBT person would look at a piece of legislation that on its face may have nothing to do with LGBTs, like let's say the healthcare reform bills that have been going through Congress, and perhaps identify an impact on the LGBT community that maybe other legislators couldn't necessarily see. And I think LGBT legislators are more likely to serve as allies for each other in efforts to pass legislation that would be helpful to the community. And I really think to ensure this type of respect, the community needs to be represented at a rate proportional to the community at large, which there's lots of different estimates, but it's somewhere between 5 and 10%, I believe. And I think that would give Americans more assurance that LGBT's interests are being taken into account in the legislative process. The reality, however, is that the LGBT representation is nowhere near that level. If you look at representation in Congress, there are 3 members of openly LGBT people in Congress, which is 0.69%. Only 0.01% of state legislative representatives are openly LGBT. No openly LGBT person has ever served in the U.S. Senate, on the Supreme Court, or as President of the United States, as far as we know. And I think, similar findings, there were similar findings regarding the dismal representation of women in our government when the court found them to be politically powerless back in the 1970s. In fact, I think the numbers here for LGBTs are probably much worse. Now, some people are not going to buy this argument. Some people are going to say, of course LGBTs have political power. Look at all the victories they have achieved in legislatures around the nation. That's just not an argument that I would buy. I think the protections that have been afforded to LGBTs are less than what women had already achieved when the court found them to be politically powerless. I mean, it's very tricky to sort of compare the achievements of 2 different minority groups. And I also think so many laws have been passed in our nation that not only are unhelpful to LGBTs, but actively target LGBTs, actively take away rights from this community. And they've all happened, in the last 10 or 20 years. If you look at DOMA, if you look at Don't Ask, Don't Tell, if you look at all of the many laws that have denied marriage to same-sex couples and also denied the opportunity to adopt children. So that's sort of my argument, that LGBTs are not respected in the legislative process because their representation is so poor, because they're not directly represented, that the court, hopefully the Supreme Court, will find them politically powerless as a result of that argument and take that fact into account when it's trying to figure out whether LGBTs should be a suspect class or not. And hopefully they will, and hopefully if they get a chance to review Prop 8, they will strike it as a result. So that's sort of my talk. I'm happy to field questions, or if you would like Mark to present first, however you'd like to do it. Okay.
Okay. That way we'll both be open for questions after. And I tend to pace. I'm going to try not to, because then I'll be far from this, but I at least would prefer to stand. First, I want to thank you for coming. Thank the Journal for putting this on, for bringing me here to speak to you, and everyone has been very nice, and this has been very kind. I'm going to talk about two issues today. It's a little, I modified a little, and I hope that's going to be all right. So one is whether same-sex marriage must be recognized generally as a matter of either equal protection or due process. And then two, if not, under what conditions are states permitted to refuse to recognize marriages validly celebrated elsewhere? And I want to look both at DOMA, at the Defense of Marriage Act, and then what happens if DOMA is repealed or struck down? So first, must such marriages be recognized generally? I want to look both at equal protection and due process. Now, I claim that same-sex marriage bans violate equal protection guarantees. Now, one reason would be possibly that orientation should be treated as a suspect or quasi-suspect class, and we have just heard that argument. Okay, and that would suffice. If this wins the day, then it is certainly my belief that exceedingly persuasive reasons could not be provided. A separate claim, which I will present pretty quickly, is that this is already a sex-based classification, and so should be getting heightened scrutiny according to current jurisprudence. So need not expand the classes, because I regrettably agree the court is probably reluctant to expand the classes. So just in the face of it, of course, same-sex marriage bans basically say a man can marry a woman and not a woman can marry a man and not a woman. So we have a kind of express classification. Now, this issue was raised in Maryland, right, where the state's same-sex marriage ban was challenged on state constitutional grounds, and the Maryland Supreme Court said, well, no, that isn't a problem, because really what's going on is we're targeting orientation and not sex. Okay, although consider how the analogous argument goes using other suspect or quasi-suspect classifications. So suppose, for example, that a state, and I won't talk about whether this is a sensible approach or anything along those lines, suppose a state were to say, well, you know, we want to target certain socioeconomic groups and we'd like to burden them. How are we going to do that? I think we'll use a race-based classification to achieve that end. Now, a court looking at that kind of statute is not going to say, oh, I see what purpose you have. You're trying to go after this socioeconomic group. Of course we'll use rational basis. Rather, they'd say, but you're expressly discriminating on the basis of race. You can't do that, or at least the state would have to have compelling state interests. The statute would have to be narrowly drawn to promote those interests. That's to say, our jurisprudence prevents states from employing certain classifications expressly. And the claim that you mean to do something else, at least in the jurisprudence, just doesn't win the day. So it would be surprising for any court to adopt the analysis offered by the Maryland Supreme Court in any other context. Okay, suppose, for example, suppose, and the state courts, of course, have been split on this. Suppose we don't look at equal protection. For whatever reason, that is off the table. Well, let's talk about due process. Since Loving versus Virginia, the court has recognized that marriage implicates a fundamental interest. That view was reaffirmed both in Zablocki versus Redhale and Turner versus Safley. Now, some will suggest that Loving is inapplicable, and this is with respect to the due process claim, not the equal protection claim. Loving is inapplicable, it said, because Loving involved couples, of course, who could have children through their union. But if you look at Loving versus Virginia, and it's a pretty small discussion in Loving on the due process analysis, most of it, of course, is equal protection, suggesting why Virginia cannot classify who can marry whom on the basis of race. But part of it is due process, And you'll note the state does very little, in fact, doesn't mention children, doesn't mention procreation, just does some vague suggestion about marriage being important for the state, for society, for our continuation. Now, why don't they focus there? Because Virginia, if you remember what Virginia was saying, well, you know, the reason we have this statute is for the sake of the children. We don't want children from interracial couples. Children of one race, regardless of race, that's fine, but not children of interracial couples. They are inferior, says the court. So the US Supreme Court isn't going there precisely because of the argument stated by Virginia. And instead, they focus on equal protection, they focus on due process, and they focus on the interests of the adults, right? So we have the freedom to marry has been long recognized as essential, as one of the vital personal rights essential to the orderly pursuit of happiness. Now, of course, that's not true for everyone. Not everyone chooses to marry, wants to marry. But for those seeking to marry, this is true of members of the LGBT community, and it's true of people who are not members of the LGBT community. It is going to be the same kind of claim. Now, then you start thinking of Zablocki versus Redhale, which involved Wisconsin's statute, which burdened the marriage rights of the indigent. How did it work? We had a statute which said, well, look, if you are a parent, you're the non-custodial parent, and you cannot support or you cannot present evidence that you can support your child, we don't want you to marry again or marry the first time, as the case may be. Why? The state didn't want more children to be born who might be supported by the state. So the state reasoned, well, if we prevent marriage, we'll probably have fewer children born, and then we're going to protect the public fisc. Well, the argument in Zablocki, well, the court, said, well, gee, that's a legitimate interest. Preserving the public fisc is always a legitimate interest. It may not win the day, but trying to save money isn't a bad thing. But of course, it didn't win the argument. Why? Well, one of the things the court noted, well, gee, if you have this law, what happens? And it turned out, if you remember, Redhale's fiancée was pregnant when they sought to marry. They couldn't marry. They didn't decide to postpone the birth. They thought that was not convenient. They already had a shower. So Then you just have children who are being born, but they're being born outside of marriage. Now, there are a variety of benefits, both financial, emotional, in terms of stability, all kinds of benefits associated with marriage, and all the state was achieving was preventing those children from enjoying those benefits rather than protecting the public fisc. But the same argument applies for members of the LGBT community who are having and raising children. All that's happening now is that those children, depending on the state, one, may not be recognized as having parent-child relationships with each of their parents, and two, may well be precluded from having parents who are married, which might have other kind of detrimental effects both on the family, whether in terms of finances, stability, support, a variety of negative effects. So that looks to be the effect, but that's also to say the same reasoning in Zablocki applies equally here. And if you want to look at Turner, which involved prison marriages, which the court recognized this was too important an interest, the court didn't even talk about children. It was more that people might get out and might have a relationship outside. Okay, so I believe there are important equal protection due process arguments in support of same-sex marriage being constitutionally protected. I admittedly do not believe the court anytime soon is going to buy them. So let's talk about interstate recognition. Okay, and what time did I start? So sorry, 25 of or 25 after? Good, okay, yeah. Okay, good. So let us consider. Now first, go back to Loving versus Virginia, right? You have Mildred Jeter, Richard Loving, they're going to marry. They're Virginia domiciliaries. They can't marry in Virginia. What do? They go to D.C. Why do they go to D.C.? D.C. doesn't have an anti-miscegenation law. Then they go back to Virginia. Well, one question, of course, is, well, what about full faith and credit? They married in D.C. where it was perfectly legal to marry. And if you look at Loving, there's no mention of full faith and credit. That's because traditionally domiciles get to determine the validity of the marriages of their domiciliaries. So you may have a law which says you can't marry here. And it may be the case you go somewhere else and marry, and your state, your domicile may choose to recognize. It's up to the state. So for example, in Ohio, where I live, first cousins cannot marry within the state. But if they go to another state, this is Ohio domiciliaries, go to another state, marry, and come back, the state says, okay. In part because if children are born of the marriage, they want the children to have the benefits of having the parents married. So there's certain interests in preserving marriages, promoting marriages. States, even if they preclude locally, can, but need not recognize if validly celebrated elsewhere. We also do not allow uncles and nieces to marry. And another case following the first involved uncle and niece who married legally in the place of celebration and then came back to Ohio and said, we have a real marriage. And the state said, not here you don't. So that's to say, in both cases, it was left up to the domicile. Now they can decide yes, they can decide no, there are various interests implicated, but it's a kind of domicile question. Now you remember when the Defense of Marriage Act was passed, why did they do it? Well, it looked like Hawaii was going to recognize same-sex marriage. Because in Hawaii, sex is a suspect classification under the state constitution. The Hawaii Supreme Court said this marriage triggers equal protection guarantees on the basis of sex. Then we had a remand. In the interim, referendum. But Congress acted fearing that Ohio domiciliaries were going to go to Hawaii, enjoy a little sun, that wouldn't be bad, marry, come back and say, you must recognize our same-sex union. But there's a long jurisprudence saying, well, it's up to the domicile, at least at the time of the marriage. So the problem that Congress was allegedly trying to correct wasn't really a problem. But the Defense of Marriage Act does much more. One, it says that individuals, no state, territory, or possession shall be required to give effect to any public act, record, or judicial proceeding of any other state, territory, possession, or tribe respecting relationship between persons of the same sex or a right or claim arising from such relationship. It's a very robust, allegedly federalist kind of statute. Basically, it gives states the rights not to recognize. Now, there are a couple things. One, that doesn't just mean Ohio domiciliaries who go to Hawaii. It does a couple other things. One, it says that during the period when individuals lived in California and could marry, according to local law, where that was their domicile, nonetheless, if they later get a job opportunity in North Carolina or in Ohio, that state can refuse to recognize the marriage, notwithstanding the individuals being domiciled in a place that recognized the marriage. Now, there's no current jurisprudence establishing that that cannot be done. That's an open question. But it's a much different story than one where I purposely evade local law with the intention of living in my home state. Right here, people marry in accord with the law of their home state, and then later, for some reason, want to move, job opportunity, be closer to ailing parents who need your help, whatever the reason. And they have to choose between helping their parents and their marriage. And it's worse if you look at DOMA, because they don't say, well, future domiciles, you get to decide. It says any state. So that means if you're going from California to Massachusetts, and Massachusetts will recognize the California marriage, but you drive through Ohio and have an accident, I'm sorry, that person that you thought was your spouse, that was your spouse last week, depends on how fast you drive across yesterday, but that's fast. Or it's going to be your spouse when you get to Massachusetts. Right now, meet this legal stranger. Now, there's another aspect of DOMA. This is only with respect to marriage recognition. It also says any right or claim arising therefrom. Now, this has not been construed, but one way to view it is to think it applies to divorce judgments, and then, for example, property division, spousal support, and a separate issue will be custody, which I'll do in a minute. Now, arguably, what does that do? That means that if I'm in California or Massachusetts or Connecticut, and I've just been ordered either to split property, which I can move with me, or pay spousal support, I think I'm moving to Atlanta. And I'm keeping it, because you're not going to get Atlanta courts, because of that state's Defense of Marriage Act, to enforce even a judgment validly issued by a court. And the reason the courts in Georgia don't have to is because of the Federal Defense of Marriage Act, which is to say, if DOMA is repealed, then our standard full faith and credit jurisprudence with respect to judgments will kick in, and at least judgments will be subject to full faith and credit. Now, a separate issue might speak to custody issues. And you might be familiar with Miller-Jenkins, which is the battle between Vermont and Virginia involving a custodial arrangement. So biological mother had a civil union partner. This is before Vermont recognized same-sex marriage. They split. Vermont courts said biological mother has custody, but the civil union ex-partner or ex-civil union partner gets visitation. Mother went back to Virginia and says no. Now, she claimed that DOMA allowed Virginia not to recognize the custodial arrangement, or which is to say that she didn't have to allow visitation. But Vermont had issued the order, and we have background federal law which will allow Vermont courts to retain jurisdiction. Right, so we have PKPA, we have, in addition, the Uniform Acts of UCCJA and UCCJEA, where it was thought at least Vermont gets to continue to decide as long as one of the parents stays. One other benefit in Miller-Jenkins was that we have a functional parent. Vermont recognizes functional parents. Why is that important? The parental relation is not by virtue of the civil union, so arguably DOMA doesn't apply. But there are a lot of couples for whom this would apply. And further, one difficulty is that a state, and now we're talking about custody of kids, a state will retain jurisdiction only as long as one of the parties stays, which means if you have a partner who moves to Virginia and you want to stay in contact with the child, you better stay in Vermont. Because otherwise Vermont will lose jurisdiction, it'll go to Virginia, and Virginia has already said in a different case, sorry, we won't recognize relationship, neither between the parents nor parent-child. Now there's yet another aspect of DOMA which is going up through the courts in Massachusetts, and that's the federal definition of marriage. Now, one, you have equal protection issues. Two, traditionally the federal government doesn't get to tell the states what their marriage laws will be. And you need to have important damage done to federal interest to justify it, which is a kind of heightened scrutiny. So arguably, for a Defense of Marriage Act, one of the most vulnerable aspects will be the federal definition of marriage, because you don't need to get heightened scrutiny. You don't need to get a finding of equal protection and due process violation. All you need to do is follow the general jurisprudence. So suppose DOMA is repealed. What effect? We're still going to go back to the system where the domicile gets to decide. So for those who want to evade local law, it's very unlikely they'd have their marriage recognized unless there were a very robust finding. But certainly we would have judgments recognized and presumably at least more confidence that as long as one's married in one's domicile, it will be much harder for courts to refuse to recognize that marriage if one is vacationing elsewhere, possibly if one emigrates elsewhere. Thank you. And I think we're open for questions.
Can either or both of you expand on the determination of the existence of a suspect class? Because I can see some people arguing like, well, gay people have lots of support in Hollywood and they've got all that money, whereas women who weren't working, didn't have an income, didn't have, like how do you quantify, besides per capita representation in Congress, which we still haven't met by a long shot for women, how do you quantify that?
Yeah, I think what you're getting at is sort of the political power prong of the different elements you look at, and you're right, there are a lot of different things that can be taken into account. Representation is one thing, looking at sort of the legislative record is another thing, and you're right, particularly in the Prop 8 litigation, the defense put up an expert that talked about, I think he may have referenced Hollywood, but certainly talked about all the money and support that the pro-gay marriage proponents put forth. And it's just one of many elements that need to be worked through, and it's whatever sort of people find the most compelling. I mean, you can argue that the gay community has access to a lot of money and resources and Hollywood, et cetera, but that doesn't take away from the fact that so many of the states have banned same-sex marriage, including in California. So it's sort of kind of a sifting out of what facts you find to be compelling and what facts the court will find compelling when it's looking at the political power prong of the test. Yeah.
So the legislative history part, would that then require a court to look at those laws and admit that they're discriminatory? Because if these laws that you're using as evidence for the discrimination have been allowed to pass all that time, aren't those sanctioned as non-discriminatory?
Yeah, I mean, I think that is part of the test. And I think you're getting at kind of another issue too, is whether some of the laws, what was sort of the motivation behind some of the laws when they're passed, because I talked about sort of the lower standard of review that can be applied, and sometimes the government, when trying to justify a law, cannot even meet that if the court is looking at sort of whether the law was motivated by prejudice, animus, et cetera. And that's been one of the issues in the Prop 8 case, is trying to figure out, well, what motivated the proponents of Prop 8 when they were trying to sell this to the public, and what sort of messages were they sending out there when they were doing their phone banking, et cetera, as to why folks should vote for Prop 8.
And you'll note sort of the difficulty of the political powerlessness with respect to groups that have already been recognized as suspect or quasi-suspect, right? So there was debate about then whether women could be considered quasi-suspect because of proportion. There was a debate about, given increased recognition of past discrimination on the basis of race, that therefore either you should no longer recognize race as a suspect classification, or it shouldn't have been, and they did not win the day. So it's a little confusing to just know how to deal with the powerlessness argument. And part of it is also ability to make connections and to forge alliances traditionally. And that, at least that's one of the things I bet they'll talk about as well.
Yeah, and I think one of the reactions some people have to the political power argument is that it doesn't matter anymore because, look at all the power, look at all the political power women have now. They have more representation in Congress. I would argue with that, by the way. Look at African Americans, they now have a president in office. And I still believe, let's say if Congress was 50% women, I still believe that we would still consider them a suspect class, and we would want the court to review those laws carefully, because we as a society, I think, no longer accept any sort of overt discrimination against women or people of color. I just think it's an entirely different scenario with the LGBT community. When we have so many laws that have been passed this decade, which take away rights from that community, I think overt discrimination is on the table. So I think it should be a relevant point.
You talked a little bit about the pushback from the gay community about filing a case challenging Prop 8 and it sort of being strategically a bad idea, given the composition of the court. I was wondering what both of you thought about that, whether the timing of that case was something that was a sort of good strategy or bad strategy.
I don't know. I mean, if I were to hazard a guess, I would say that I think Judge Walker will probably overturn Proposition 8 and it will go forward. And I certainly think the lawyers working on that case are tremendous. And the fact that we have a lawyer with strong roots in the Republican Party is Ted Olson is a huge advantage. I think folks are hesitant because, not that many states have approved same-sex marriage yet, and it's certainly a risk going forward. I think, though, there's a lot of momentum and there's a lot of positive things that have come out of the litigation. I would say I would probably be glad that it was filed.
And one of the fears, in a way, is this is California, and you think California domestic partnership, which is basically a civil union, right, in other states, because it's a very robust partnership. The difference between that and a marriage, at least in terms of benefits, especially with federal DOMA still upheld, we have to go the symbolic realm. That was enough in Connecticut, which also had civil union, but it's not been enough in various other states even. It's not as stark a contrast as in my state, which says marriage, not marriage, right? So this is a more difficult one, and one of the fears, especially if you look at the opinions, is that they're not always narrowly written. So it'd be great if it were broad and affirming rights. That'd be wonderful, sort of Lawrence-like. But if it goes the other way, this is scary. So this is a long way of saying pretty ambivalent.
When discussing a suspect class and defining the class, obviously women, it's easy to tell with looking at a woman who's a woman for the most, and looking like race, what people, So I can envision the court potentially not even getting to the political question thing and more just being like, well, how would we define this class? Like, where do you see that argument? Like, how the class gets defined?
I guess I don't see that as much of an issue because they would particularly be looking at same-sex marriage. So they would be looking at whoever is motivated to marry someone of the same sex.
Although this analysis came up in Equality Foundation out of Ohio, where we had a local referendum like Colorado's Romer referendum. We just had on local level, and the district court basically said no class. We don't know, how do we tell? And the Sixth Circuit, not the most progressive of the circuits, upheld. It's sort of a harder one. I'd be more tempted, though, to point to religion as a suspect class, and it's much harder to tell, absent my saying something or my doing particular things, what my religious beliefs are, what my practices are, and that makes me think it may not play the role, but I'm confident were this to go to the court, Justices Scalia, maybe Justice Thomas or Alito or Roberts might well suggest, what do you mean? So it depends on which classes you want to focus on as to whether that's going to be a tough one or well, we haven't used it before.
A lot of the focus on DOMA has been on, sort of the G prong of LGBT, but what about transgendered individuals? And I know a lot of states have different requirements for what you have to do to change your birth certificate,
Right.
for example. Are there any cases on that?
Well, one of the interesting things in a way is if you look at the language of DOMA, DOMA says that it will allow states not to recognize a same-sex marriage under the laws of the other state. So it's unclear if that means a marriage under the other state, which this state views as same-sex, or instead, if it has to be in the eyes of the other state, a same-sex marriage. Why say that? You think of Gardner, or you think of Littleton, right, where you have transgendered individuals, right, who are post-operative, who are accepted by their current spouses. Their spouses know about their history, love them, marry them anyway. And in Texas, you have someone, actually in Texas it was all local. In Kansas, this was by virtue of Wisconsin's recognizing that J. Noel Ball was a woman. And arguably, you didn't get DOMA to kick in. But nonetheless, Kansas said, we don't recognize you as a woman to her, and therefore, you don't have a marriage. But they didn't base it on DOMA. They just said, this is what we're doing. So I can't tell how much work the Federal Defense of Marriage Act is doing here, but it's not only with respect to the birth certificates, but it's also with respect to whether one state will recognize the birth certificate from another, and especially if their conditions differ. But one other thing, because it's a record, and our full faith and credit guarantees are not as strong for records, it's not so clear that DOMA is what's allowing the states to do this, but it's really very difficult because that's another way in which a marriage here, a marriage in New Jersey will not be recognized in Texas if it's involving a transgendered individual. Just because they have different, I mean, New Jersey will do more identification and Texas goes to look at either birth certificates or chromosomes or something like that. All the traveling difficulties I was discussing before apply all the more strongly for transgendered families or families involving a transgendered individual.
I guess that's it. Thank you very much.